Welcome back for another segment of Ask an Attorney with Mike Kuna of Kuna Law Firm PLLC. Good morning, Mike.
Good morning, Sophia.
Are you ready for this question?
I am.
Wonderful. Let's get into it. Today's question is, I remember that a couple of months ago you spoke about slips and falls, and now that it happened to me, I need your help myself. You see, yesterday I went to the mall in my small town for a manicure and a pedicure. Once I was finished and I was walking out, I was sending my daughters the photos. I slipped and fell because they were mopping the floors. I did injure my elbow and broke my phone. Do you think I can get a lot of money out of this? Thank you so much.
Naturally. It's always about the money. So first, let's begin with the statute of limitations. In personal injury cases, the statute of limitations is 6 years, usually from the date of the injury. So you do have a sufficient amount of time to file your claim. Second, I would like to discuss the actual damages a person can get from a personal injury, such as a slip and fall. First, we have economic damages. What are economic damages? Loss of wages, for example. Sophia, you make like $2 million a year?
Mm-hmm.
So if you don't work for 1 month, that's a big amount of money, right?
Yes, definitely.
Yes, we don't want Sophia to fall here. We also have medical bills. We also have days we have to take off to go to the doctor. And we have other losses, for example, a broken phone. But we also have non-economic damages, mostly known as pain and suffering damages, or changes in the quality of life. For example, Sophia, how old are you?
22.
And I presume you're very active.
Yeah, I'd say so.
Yes. Is the person gonna suffer a period of inactivity because of their injury, or is a person very old and not active and therefore will not suffer it? These are more subjective damages. And on top of that, we have the third type of damages, which is called punitive damages, which are usually granted in really, really rare cases of gross negligence. For example, a place that did not put any warning signs, that had ditches, and people had severe injuries from that. However, in North Dakota, we also have a specific rule. Ready for that, Sophia?
Mm-hmm.
You know the rule?
Do I?
Yeah.
I don't think so.
Because most people don't.
Mm-hmm.
That rule is known mostly to lawyers. It's called the modified comparative fault rule. That rule says that if somebody is guilty of more than 50% of the damages or 50% of the damages, they should not be compensated. And if they're guilty of a lesser percentage of the damages, it should be deducted from the lesser amount. Sophia, let's take you as an example, okay?
Mm-hmm.
Let's say you slipped and fell in the mall, okay? And you are supposed to receive $1 million in damages, okay?
Okay.
If the jury finds that Sophia is guilty of 45% of the damage given to her, out of those $1 million, $450,000 will be reduced. However, if the court finds that Sophia is guilty of 50% or more of the damages that were caused to her, she will get absolutely no compensation. On top of this, there are other issues that usually we deal with in court. The entire issue of medical expertise, the time frames in which we need to file medical affidavits, the experts that we work with, and the experts that the other party usually uses. Also, we have to remember that insurance companies are for-profit organizations, and it's their very interest to pay you less than more. Therefore, again, it's a complex issue that I will not be able to answer in such a short time frame. Just call us directly, 701-404-7768, and we will speak to you gladly about the subject.
Wow, Mike, I can't believe that you remember all that information like that.
It's my daily job, as they say.
Yeah, I mean, I get to cheat with my teleprompter, but you just rattled it off. Seriously, that is so impressive.
Thank you.
Of course. If you would like to ask Mike a question, you can go to the Valley News website and click on the Ask an Attorney tab.